everyone. Welcome to the Attorneys on Retainer live stream. My name is Rachel Moss, and I am here with attorney Marc Victor. Today, we will be talking the top mistakes people make before and after a self-defense incident. Thank you, everyone, for your patience. Just like our friends in Hollywood, we had some minor technical difficulties, but we are ready to kick off this live stream. At any time, if you have any questions, go ahead, put them in the chat, and our team will flash them on the screen. Before we get started, I wanted to remind everyone that Marc and I are both licensed in Arizona. He is also licensed in Hawaii. So we will not be doing many state-specific questions, but just generally discussing the common mistakes in self-defense as today. We also will not be discussing regulatory questions. As a reminder, this live stream does not constitute legal advice, and it does not establish an attorney-client relationship. But now that we've gone past that disclaimer, I want to kick it off to Marc. Welcome to the live stream.
Yeah, it's great to be here. I guess this is the Attorneys on Retainer live stream. Take two. You got to
right.
be, you got to be ready for technical difficulties. Life throws you curveballs sometimes, and you just got to be ready to deal with them. So let's get right into it. Common mistakes. There are a lot of mistakes. Talk about the first one, Rachel. Get us started.
Yes, a very common mistake is that people use force too quickly. We see this a lot, and there's many times that people use force too quickly. Sometimes they're not facing an imminent threat. Sometimes the threat is just mere words without something else, and this is really important. Kind of a silly example I give sometimes is that imagine if someone approached you and said, hey, I'm going to shoot you in 10 minutes. So you have a 10-minute warning. That might feel like a real threat. It might feel very scary. And that person might really intend to shoot you in 10 minutes. However, that is not an imminent threat. At that point, if you were to pull out a firearm and defend yourself, you would not be justified under the law.
Yeah, you definitely have a problem there. This is an example that I've used as I've been speaking at the Crossroads of the West Gun Show for the last 20 or so years. I've often said, hey, if one of you guys out there gets a little rowdy and says, you know what, I'm going to punch you in the face. I'm going to go to the bathroom first, and as soon as I come back, I'm going to punch you in the face. I say, raise your hand if you can take action now. And some people raise their hand. They say, a threat has been made. But the right answer is you got to wait until the person comes back from the bathroom. Reminds me that this happens so often. We really don't have to reach back very far to think of a real-world example here. I took a strike force call very, very recently, and it was a situation where a person pulled their firearm in response to a person making threats. And the person wasn't really very close. It was really just words only. There were no weapons involved. There was nothing like that. And I said, look, it's always good advice to keep your mouth shut. We always advise that. But especially in this case, because, if you say what happened, you're handing the prosecutor a charge right there. The first thing they're going to seize on is a lack of imminency. That's really the key here, right? In order to use self-defense, whether it's ordinary physical force or deadly physical force, any kind of force, if you're going to claim self-defense, the threat against which you are acting has to be right now. It's got to be imminent. So you really got to think about that, especially in the case where you're thinking about pulling out a firearm, right? We all know you got to be dealing with a serious threat of death or serious physical injury, but it's got to be right now. You pull out that firearm too quickly, you just bought yourself a very serious prosecution. And it was interesting. I said to the person, look, I think you blew it, so keep your mouth shut. We're still going to defend you. You don't have to get it right. As long as you intended to act in self-defense, we got your back. The whole team is going to represent you. And I could hear the sigh of relief on the other side of the phone because she knew she had blown it by pulling out the firearm a little too quickly, but I wanted to assure her we got your back nonetheless.
Exactly. And then what about another scenario? What if someone came up to you, Marc, and said some really rude things, some things you didn't like, and they were, being kind of mean to you? What would you do then?
What would I do? I'd probably just smile and say, I feel bad for you, man. We're all on the planet a short time. Enjoy your life. Move on. One thing I wouldn't do is start throwing punches, right? People who understand self-defense, and this hopefully is all our AOR clients, they know about the mere words doctrine, right? They know no matter what somebody says, no matter how offensive, it doesn't matter if they said something terrible about your spouse or your religion or your favorite sports team or whatever, no matter how offensive it is, look, this is free speech, right? We're living in a free country. People get to say whatever ridiculous things they want to say. If you're claiming you acted in self-defense because somebody said something you didn't like, you're definitely going to be in the wrong. Now, keep in mind, you can contrast that with words plus some action. And so that's one of the reasons I tell people to just shut up, right? There have been cases that we've had over the years where I said, why did you hit them? Well, they said such an offensive thing. I said, that's it? Really? And they say, well, I think so. Well, was the person walking towards you as they were saying it? Yeah, maybe. Were their fists like this? Maybe. Okay, now we got something to chew on. That's one of the reasons you keep your big mouth shut. So anyways, bottom line, don't ever use physical force if all you are responding to are mere words. That is never going to be self-defense anywhere.
That's right. There needs to be some realistic threat of deadly physical force, or in the case of an ordinary physical force defense, an ordinary physical force threat, in order for you to then respond with your own force.
Yeah, you don't have to wait until somebody punches you in the face. Self-defense, doesn't require you to have to wait, but it's got to be an imminent threat. It's got to be right there upon you, because what the law says in such a case, if you've got time, if it's not imminent, look, you got to get out of there, and some states have duty to retreat in any event, even if it is imminent, which, fortunately, there's a minority of states. But in other places, lots of times someone will say, I'm going to do this or that. I'm going to go drive to my house and get a gun or something. You got to go to court and get an order of protection in such a case, or do something else. You don't get to preemptively use self-defense unless the threat is right there upon you. We use the word imminent in the law.
And let's talk about duty to retreat. So, like you said, most states do not have a duty to retreat, but some do. Now, some attorneys argue that there's a little bit of a paradox to the duty to retreat doctrine, that if you're in a situation where you had the duty to retreat, if it really is an imminent scenario, then you can't possibly safely retreat if you're really facing an imminent threat of deadly physical force. However, you might be able to contemplate some situations where a threat is imminent and you can safely retreat. And in those states, if you have that ability to safely retreat, if you do not do so, you will be facing a serious prosecution.
Yeah, I mean, it's there's a lot to talk about here. First off, in all the states that have a duty to retreat, you never have to retreat if you are in your home, right? So we call that the castle doctrine, right? Your home is your castle. You don't have to retreat from your castle. Some states will extend that further and say you don't have to retreat. These are, remember, only the duty to retreat states. They'll say you don't have a duty to retreat maybe at work or maybe in a vehicle. You have to check the state you're in. Most states don't have such a duty. But it's true. I've had this conversation with an elected county attorney. I've also had the conversation with a currently serving Supreme Court justice, and I've said, do you ever see a situation where you can retreat in complete safety and you're still facing an imminent threat of death or serious physical injury? It's sort of hard to think of that type of a situation, right? Because in these states where you have a duty to retreat, it's not under all circumstances. It's only if you can do so in complete safety. But if you can retreat in complete safety, how are you facing an imminent threat of death or serious physical injury, or even in the case of ordinary self-defense, an ordinary threat? So it's sort of hard to envision, and maybe somebody out there can come up with such a circumstance, but it's never arisen in my career that I can think of a time where the threat was imminent and you could still retreat in complete safety.
So this scenario is pretty unlikely to come up based on our experience, but if you are one of those people in that rare type of situation, then you would have to retreat first if you are in a duty to retreat state. Now, the next common mistake I wanted to talk about is the aggressor doctrine. So what if you were the aggressor in a self-defense situation? So let's say you started it. If you were the aggressor and started attacking someone else, you do not then have the right to self-defense. However, there are some times where you can reclaim that right to self-defense.
Yeah, a good rule of thumb here is don't be an aggressor and you won't have to worry about the aggressor doctrine.
I like that.
Yeah, I think there's no reason you should ever be an aggressor, right? I mean, but if you are an aggressor, there may come a point where you say, look, I've had enough. I am now going to retreat. I'm going to stop. I'm going to withdraw. And, very important for the aggressor doctrine, I'm going to communicate that to the other person. If you don't communicate that, then they don't understand that. The burden is on you to communicate that. So you imagine a situation where an aggressor, someone has started a fight. They said, you know what, I don't like the look on your face, and I'm going to start a fight with you, and you get into a fight. And now they decide, the fight's not exactly going as I had planned. I think I've had enough. You got to withdraw, and you got to say, okay, dude, I've had enough. I'm out. And then if the other person continues to advance against you, now at least you have a good argument that you have regained your right to self-defense. Another way that this can come up, that does sometimes come up, imagine you're an aggressor in a fist fight, and you've started a fist fight, and it's, imagine both parties are the same size. It's a very evenly matched fight, and the other person pulls out a firearm. Okay, well now they might be, it seems they're using excessive force there, right? This is disproportional, probably a bad use of that firearm. You may have an argument here that you've regained your right to self-defense because now this person has sort of upped the ante by wrongfully or disproportionately using deadly physical force in response to mere ordinary physical force. You got to be very careful. It's a good rule of thumb. If you're acting in self-defense, use the least amount of force that is reasonably necessary to repel that imminent threat.
Exactly. And then another thing I wanted to talk about is the display of a firearm. Some people think just displaying your firearm is a safe way to go in all situations. Oh, they're not going to charge me if all I'm doing is a simple display. However, if you're not facing a serious threat or an imminent threat of physical force or deadly physical force, you do not get to display your firearm. You just don't. You actually have to have that threat. And you can be charged with a crime if you display your firearm. And it can sometimes surprise people the type of crime they can be charged with. Even if you do not fire your gun, you can be charged with something like aggravated assault just for pointing your gun at someone else.
It's amazing how many people do not understand this point. I can't even count the number of people who have come into my office charged with aggravated assault, sat down on the chair and said, Mark, this is going to be the easiest case for you. And I say, why is that? And they said, well, I never even touched anybody, and I'm charged with aggravated assault. Imagine how they must feel when I say, you don't have to actually touch anybody. You just intend to put somebody in fear of an imminent touching. That's generally enough in most places to constitute an assault. And if you do that with a firearm, you're looking at an aggravated assault. That's going to be mandatory prison in so many places. So, a finer point here, right? Again, use the least amount of force. If you're thinking about the firearm and you can start by saying, look, dude, I got a gun, back off. That's all you do. If that gets the job done, do that. Don't pull it out and point it at somebody. If you can say, look, I got a gun, and you got to show the gun, fine. If you just got to pull it out and don't point it at anybody, fine. If you got to point it at somebody, fine. Use the least amount of force that is reasonably necessary, even though, the categories of force and deadly force don't really break it down in the law. When you're at trial and you're arguing to a jury, I want to be able to say my client used the least amount of force that was reasonably necessary, not what the prosecutor is going to want, which is to paint my client as a yahoo, somebody who was excited about pulling out their firearm. And as I've often said, if you're excited about pulling out your firearm, you should really think twice about carrying a gun.
I completely agree.
Totally.
And there are times where you might be justified in pulling out your firearm and firing a shot, but you choose to do the less lethal option of just displaying a gun. That's a great option if you are able to safely do that in that situation. And that reminds me of something else people do. A lot of people like to fire warning shots, and I really get the inclination to do this because, again, you see it as a less than lethal option, and you see it as a way to maybe diffuse a situation without anyone needing to get hurt. Unfortunately, unlike displaying your firearm, warning shots are not necessarily legal where you live. Many states consider warning shots to be illegal, or they will just not issue a self-defense jury instruction when you go to trial. And that's really important because if you go to trial on something like an aggravated assault or a murder and you do not get that self-defense jury instruction, you're just not going to be acquitted.
Yeah, you're going to have a hard time there. I said, look, if the choice is between shooting and killing somebody or firing a warning shot up into the sky, those are the two choices, and you can get it done with the warning shot. probably a better option. But remember, you are going to be responsible for wherever that round goes. And if that round comes back down and strikes an innocent bystander, guess who's getting charged with either aggravated assault or some version of a reckless manslaughter? That's going to be you as well. So always better to avoid that. Look, even in the cases where you don't have a duty to retreat, imagine you're in a state that you have no duty to retreat. If you can retreat and avoid the whole mess, that's always the smartest thing to do. Look, I've been representing people for over 30 years. If you can avoid getting engulfed in a prosecution that's going to go on for a year or 2 years, this is all you're going to think about when you wake up in the morning and before you go to bed at night, it's going to really ruin your life for quite a bit of time. Even if you win, you're still not going to feel like a winner. So if there is a way to avoid the situation, think situational awareness, right? Don't go into the places where you feel, you more likely you're going to need to pull out your firearm. If you can just de-escalate it, think verbal judo. If you could say, look, man, no problem. You're right. I'm wrong. I'm just going to move on. You really got to check your ego if you're going to carry a firearm.
Yeah, and unfortunately with warning shots, I've seen times where prosecutors will argue that the fact that you fired a warning shot shows that maybe you weren't really facing an imminent threat. Because they said, well, if it was imminent, then you would have fired it at the person. So you just need to keep things like that in mind. Prosecutors will argue things that may not be what we would actually think of as the common person. They think a little bit differently. So those are the types of things we need to think about in a self-defense situation.
Yeah, they're going to Monday morning quarterback the whole thing, and no matter what you do, they're going to take the worst inference against you. Remember, they want that conviction. And so this is why really you got to keep your mouth shut. Let us first establish what the evidence is, and then if we want to we're not against statements. We just rather you make the statement after we know what all the evidence is, or maybe at trial for the first time.
And then another mistake I always like to bring up is the fact that you cannot use deadly physical force to defend your property. And believe it, I love my property as much as the next person. If someone came after my purse or my car, I would be angry about it. But you are not justified in using deadly physical force just because someone is either trying to steal or destroy your property. And something that may surprise people is that in many states, unfortunately, your pets are considered your property. And so I know that's really hard to think if someone's going after your dog or your cat that you're not entitled to deadly physical force. But humans and animals are treated very differently under the law. So you need to be careful if someone's attacking one of your animals. You may not be able to step in and use deadly physical force to protect them.
I got to say, I don't love the rule here. I mean, I think there's probably, if I was sort of reestablishing what the law should be, I would probably say, property over a certain value, you get to protect with deadly physical force. And I know Texas has a rule. It's not quite as clear as people like to paint it. There are still, some little nuances to that rule. But in most places, I think all places other than Texas, you just don't ever, no matter how valuable the property is, no matter how unique it is, how much you love the property, you don't get to use or threaten to use deadly physical force just to protect property, right? You can see the judgment on the other side. What they're going to say is this is not the kind of thing that we want a human life to be taken for. But, on the other hand, you may have worked your whole life. You may have your life savings in a bag of gold coins or something you've been saving up your whole life, and here comes some punk kid who breaks in your house and grabs your gold coins and is now going to outrun you, and there goes your whole life work. The law is you can't shoot him. But I got to say, if some states wanted to experiment with that, this would be a good deterrent for at least thievery of high-value items. But that is not the law today. You cannot use deadly physical force to protect property. But, the case that you raised with the dog, this comes up all the time. We get calls all the time with people walking their dogs, and some other dog comes over, and now there's a big dog fight thing. If you shoot the other dog, and what you say to the cop is, I shot the dog because he was attacking my dog, wrong answer, right? You just bought yourself a very serious prosecution. If, on the other hand, you kept your mouth shut and then let us maybe ask you some questions, were you afraid of that dog? Wasn't that dog right there imminently going to attack you? Yeah, I think the dog he was attacking my dog, but I was really worried he was about to attack me. Okay, that's a completely different situation. Now, you are not using deadly force just to protect property. You're using deadly force to protect yourself, or another person is fine as well.
Exactly. And again, like you said, this is a tough situation. I know many of us want to step in and protect our pets, protect our really valuable property in situations like this. But under the current state of the law, you cannot use deadly physical force. You can use ordinary physical force to protect your property.
That's right.
However, there's times where it may or may not be worth it to do that, depending on the situation, but that's a judgment call for that situation.
Yeah, and even then you got to be proportional, right? And you imagine the 8-year-old girl is going to steal your basketball or something. You don't get to punch her in the face, right? You can gently stop her, take the ball away. I mean, you're a jerk, but at least you're acting within the law. So even then, and I've had cases as well where ordinary physical force was used, and my client used ordinary physical force in response to a threat of ordinary physical force, but kept beating the guy. And I remember seeing, wow, my guy really won the fight. It was a bloody mess, and the prosecutor said, I think your guy used more force than was reasonably necessary, and I'm thinking about charging your guy. So those can be sticky situations. Remember, the rule on proportionality doesn't just apply to ordinary physical force and deadly physical force. You can still make that argument within each category.
And I always like to remind people of the crime prevention statutes as well.
Yeah, good point.
This is something that's different in every state. In Arizona, for example, our crime prevention statute allows people to use deadly physical force to step in certain situations. So going back to property, there may be some limited circumstances under something like an armed robbery or a burglary where you would then be able to use deadly physical force. But this does not apply to all situations where your property may be at risk.
Yeah, usually the wording is something like if it's immediately necessary to prevent the commission of one of the following crimes. But there again, this is another fun question to talk about. When you couldn't have stopped this crime by using ordinary physical force. Grab the person and say stop, robbing or doing something like that. That's what the prosecutor is going to argue. You got to remember, whenever you're pulling out your firearm, you should expect to be prosecuted. If you're not willing to be prosecuted, then probably the threat against which you are acting is not serious enough. And I don't want to be prosecuted. So for me to pull out a firearm, somebody's going to be dead or really seriously injured. Otherwise, you know what? I don't want to be prosecuted. I'll pass. I'll get punched in the face. If that's all that's going to happen, I'll take the punch in the face before I pull out my firearm. I don't want to be prosecuted.
Yeah, what I always remind myself as a firearms owner that even if I do everything exactly correct, that may not be how like a prosecutor or an officer sees it. Maybe there's a witness that only saw part of the situation and gave a somewhat false report to an officer. Maybe the officers just don't believe your story.
That's right.
Maybe you have a crazy jury. Juries do wild things and come up with verdicts that don't always make sense under the law. So I always remind myself that anytime I'm in a situation, the end result here could be prison. And if I don't prefer prison over the current result, then I need to put my firearm away.
Yeah, and you got to remember that reasonable minds disagree over what's reasonable.
Yes.
Right? The whole ball of wax on self-defense is what's reasonable. At the end of the day, that's really the only question. And reasonable minds differ. Andy and I argue sometimes over different cases, and we're going to be coming out with a new series where we put some tough hypotheticals out there, and people can go either side on these, but we just want to really demonstrate that many of these questions, you could line up a bunch of experts in the room on self-defense, and they're not all going to agree on whether this is a valid act of self-defense or not.
And I think we might have our first question of the live
All
stream.
right.
So do aftermarket parts on EDC firearms look bad in court after a self-defense incident occurs?
I've had variations of this question throughout my entire career, and I have yet to see a prosecution that it really made a difference, right? And it may depend on the modification. I have seen some where people put some what I would call spirited sayings on their firearms, and prosecutors will attempt to use that to go to mens rea, what you were thinking. But the kind of modification that just makes the firearm easier to use or more accurate to fire, a scope or something like that, or something with the trigger in terms of how much pressure you need to pull on the trigger. I have yet to see a case where that made it. I'm not saying that none exist, but either you were justified in using deadly physical force or you weren't is going to be the argument in court. So I personally don't think it's that big of a deal if you make modifications to your firearm. But don't put a saying on there, man, I can't wait to shoot somebody or lights, the kinds of things we said in the Marine Corps. Don't put those kinds of things on your firearm.
That's right. I know many people want to modify their everyday carry firearms, and I agree with you, but I just want to remind people prosecutors can argue whatever they want. So even if it's a stupid argument, they can make it. There's things that we can do as attorneys to stop them. We might file a motion to preclude certain evidence from coming in or object to certain arguments the prosecutors make. But at the end of the day, that's a call for the judge on what comes in. And prosecutors can make arguments about how you modify your firearm. However, a good attorney should be able to counter those arguments and explain why those modifications to your everyday carry firearm don't necessarily matter in terms of what the self-defense statute says, which is reasonableness going into imminency and whether or not the defense situation was proportionate.
Yeah, and if you bought the firearm used, I mean, who's to say who modified it, right? I mean, the defendant doesn't have to make any particular statement, may not testify at trial. And so, you may have a good argument with the judge that these modifications, the state can't prove that they were even made by my client. This was purchased in a used market. So, just like when you purchase a vehicle, sometimes people change the rims or change this or change that. But I have not seen this, even though this question comes up a lot, I have not seen it as a major factor in any case I've been involved in over 30 years now.
The same with me. But again, really, all of these questions boil down to reasonableness. And another time where reasonableness really comes into play is talking about the castle doctrine. So the castle doctrine, you touched on this earlier, the idea that your home is your castle, that you're entitled to some extra protection when you're in your own home. So if someone was to enter your home and you were to act in self-defense and use deadly physical force, you are entitled to a presumption of reasonableness because it happened in your home. But I always like to remind people that's a presumption. It's not end of story, you were reasonable. It's not a get out of jail free card for anything happening. Going back to what you said about the 8-year-old girl with the basketball. Let's say an 8-year-old girl stumbles into your house and you can tell it's an 8-year-old girl. And even if she's coming at you, running at you, you don't get to shoot the 8-year-old girl in your home. That's a presumption of reasonableness that can easily be rebutted by a prosecutor in court.
Yeah, I mean, again, bottom line, keep in your mind that I always, under all circumstances, will use the least amount of force that is reasonably necessary to repel that threat. And even if you're in your home, I'm sorry. If you can retreat and avoid the situation, you're not required to do that, but that's the smart thing to do. And if you're not intending to do the smart thing, you shouldn't be carrying a firearm because, look, even though you're an AOR client, we're going to bring our team, we're going to fight the thing hard, you are going to get a very aggressive defense. You don't want to be in that situation if you can avoid it. I've gone through too many trials. Nobody enjoys sitting at the defense table, looking at that jury, wondering, what are they thinking? How did they like that witness? What's in their mind? Do they like me? Do they hate me? That is a very high-stress situation because in almost all of these types of cases, if that jury comes back and says guilty, you're going into custody. Your life is over for quite some time, especially if a firearm is involved. So avoid that situation if you can. Sometimes you can't, and you got to make the right decision. It doesn't mean that everybody's getting charged, right? We've had many, many cases where we have convinced a prosecutor to not bring charges, many cases where they have brought charges, and we've convinced them to dismiss charges. So all of that's possible, but best to avoid the situation. And so really you should think some of these through in your mind hypothetically. What would I do if this happened? What would I do if that happened? So you have sort of a plan. And that's really what our new series where we're going to deal with these hypotheticals is calculated to get people to think. So I hope people tune in for that series.
Yeah, that's great. And I encourage people to go back and watch our client testimonials. You'll see people say, I loved having AOR on my side. My attorneys did a great job. They got my charges dismissed. But you will not hear one of our clients say, I just loved the process of being charged with a crime. I loved going to court. I loved wondering if I would get prison or jail or a dismissal in this case. No one's saying they love that process. So keep that in mind in a self-defense situation.
Totally.
So we've talked a lot about the before. There's, as you can see, many mistakes you can make before a self-defense situation. Now let's dive into the after. I think I shouldn't let Mark say this one, but I might steal his thunder, his catchphrase. Rule number 1, just shut up. Come on, it's obvious. After a self-defense situation, your mind is going to be racing. It's a crazy time. And it's very tempting to make a statement. I get that. That's the natural inclination, I think, anytime. I've been stopped for a speeding ticket before, and even I wanted to try to explain my way out to an officer. But it's best in these situations to just shut up.
Yeah, I don't know. Speeding tickets I might feel a little differently about. But certainly after you've deployed your firearm and you're looking at serious charges. And I know, look, very, very few criminal defense lawyers will disagree with us on this. That's because we're in the trenches, right? And 99 out of 100 times, if you open your mouth, that's going to be the worst piece of evidence in the case. You're not prepared to make a statement at that time. You're freaked out. You might leave an important detail out. How do you even know that this officer is going to write down whatever you said accurately? There's just so many reasons to just shut up. There might be, you could probably paint a situation where maybe it might make sense to say something. But the problem is, as a general piece of advice, you're not going to, some people say, well, say I'm having heart problems. I want to go to the hospital or this or that. What if that's not true? Now you look like a liar. You look like you made up a story. So, and that can really hurt your credibility. So I am not in favor of just sort of manufacturing certain statements out there, saying certain things. Plus, also, once you start talking, a lot of these officers are really good. What do you mean by that? You said, well, help me understand what you said. And they'll keep you talking and keep you talking. They will get you to say something you didn't want to say. So it really is best just to shut up. If you got to say something, say, I want my attorney. Like if you just can't resist the urge to talk, that actually is a little bit better because once you, in an unequivocal way, say, I want my lawyer, they got to stop trying to get you to say anything. If you kind of fart around with, do I need a lawyer? I think I might need a lawyer. None of that's going to get you there. We've had a lot of cases on these points. You cannot be equivocal about whether or not you want your lawyer. They'll say, well, if you didn't do anything wrong, you probably don't need a lawyer. I don't know. I mean, if you really want to get you in, they will get you talking. They are good at this. Say, you know what? I want my lawyer present. Even better. I want to call my lawyer right now. That's even better. So those are, if you can't resist talking to the police, I'd prefer you say that. But for most people, in most cases, keep your mouth shut. If you're an AOR client, you call us. You'll be on the phone with us within seconds. We will then try to talk to the police. If there's evidence to, we'll talk to you first. There might be evidence to preserve or some witnesses to interview. We can communicate all that on your behalf. But to open your mouth at the scene when you got so much at stake, to know that if you say the wrong thing, if they write the wrong thing down, I've seen that too. I have seen officers make honest mistakes in what the, why do I say that? Because we've also had recorded statements and the officer will write down erroneously what somebody said. It's never going to be better for you when they make a mistake. It's always worse. It's so much better to just keep your mouth shut. Doesn't mean you can never make a statement. Can we just see what the evidence is?
But that's why you call us first.
That's right.
We're going to be able to tell you if this is a time where we make a statement or not. With that, I think we want to go to our next question. So AOR, if I'm in a shooting, call the fuzz, then hang up from them, is it then that I call AOR? Will I have time to say what's needed? The calling AOR part seems vague to me. Thanks and Semper Fi, Frank. Thank you for that question, Frank. That is an excellent question, and I think I'm going to give you a lawyer's favorite answer, which it depends. It depends on the situation, because there are going to be times where someone's life is in danger currently. If someone's life is still in danger, that is not the best time to call AOR. If you are still facing the threat, or if someone is seriously injured and needs medical attention, get that person that medical attention, deal with the threat first, and call 911. However, you want to be careful in what you say when you call 911.
Yeah, first thing I want to say is Semper Fi to my brother out there, Devil Dog. It's true. If you got somebody bleeding out on your floor, right, and you call AOR first, they can't report anything you said to us. All that's attorney-client privilege. What's not attorney-client privilege is that, he called his lawyer. This guy's bleeding out on the floor. He must have wanted to kill him. Like, we want to avoid that. So you can call 911. What should you say? As little as possible. Don't say, I shot somebody. You could say, someone has been shot. Here's the address. Please send medical attention. Goodbye. Click, hang up, then call us. We'll have a quick conversation with you about what happened. The first thing we're going to tell you is don't get shot, right? The police are coming. They don't know what the situation is there. The last thing you want to do is have a firearm in your hand. Secure that firearm. Make sure you present as absolutely no threat whatsoever. And then let's put us on the phone with them and we can communicate whatever needs to be communicated there. We are not really as focused on whether you're getting arrested or not. That's not the life-changing event that we're trying to get you out of here. What we're trying to make sure is you don't say anything that screws up the next 10 or 20 years of your life. And that's why we're telling you, keep your mouth shut. If we got time to talk on the phone, and lots of times we do, we can get enough information to communicate things to the police officer right there. They don't have to talk to us, but a lot of times they do. I've had very productive conversations with police officers right there at the scene. In fact, the good ones, the ones who advise each other to shut up after a shooting and teach their kids exactly the same thing, they are absolutely going to respect the fact that this is not the right time to make a statement to the police. They're not going to be upset. A good cop is not going to be upset because you just discharged your firearm and now you are not going to make a statement.
Yeah, we've had times where we've been on the phone with a client where they say, I'm going to talk to the police real quick. I'll come back in a second. That is such a critical mistake. The best times are when you can hand the phone over to the officer. We're on the line and we're able to talk to the officer directly. One of my favorite calls, the client told me after the call that I had with the officer that the officer had started to write a citation. I started speaking to the officer and the officer tore it up after speaking with me. And I'm not sure if it would have gone the same way if the client had been the one on the phone with the officer. So that's why it's critical. Allow us to talk to the officers in that situation if they're okay with it.
Yeah, this isn't something that really most people have at their fingertips, right? This is something that is really pretty, I would say, unique to AOR. Like, if you're an AOR client, that means you got the hotline number. Like, we are standing by. We all know here what the strike force is about and how seriously we take it. If you call that emergency number, please don't call the emergency number and say, I want to update my credit card or had a question about the program. Like, we spring into action. The strike force we take very seriously. But if you call on an urgent situation, you are within seconds going to be talking with me or Andy or Rachel or Emma, one of the lawyers here at our law firm, who will stay on the case until that case is resolved. Why would you figure out for yourself what to say at the scene? This is part of what you're paying for with AOR. You got a lawyer literally standing by 24/7, 365. To not take advantage of that, in my opinion, is just really not using your membership properly. We love this stuff. That's why we're standing by. Don't be dumb and start talking to the police on your own because you don't know. I mean, just think for a moment. What if they don't write down correctly what you said? You're stuck with what they say now. They're going to get on the stand and testify. This is what he told me. This is what I remember. It's not always a recording of what you said.
And when it comes to these two big pieces of advice that we're going over, just shut up and don't get shot, I encourage people sometimes to put yourself in the frame of mind of a police officer. What is an officer thinking when they're coming to the scene? They don't know hardly anything about what occurred. So if you're tempted to make a statement, a lot of people tell me, what if I say I was in fear for my life? That's some common advice that other attorneys give out to people. And
attorneys who don't do this stuff. Attorneys who don't do this. I know what I'll let you say it.
I disagree with that advice because there are so many times where officers are responding to the scene, they don't even know that you were the shooter. And suddenly you have identified yourself as the shooter. And there are times when an officer will have figured it out eventually, but there are also times where there's not enough evidence to prove that you were the one that fired the shot. And if you supply that information to the officers, you've just signed yourself up for a potentially lengthy prosecution if the officers are not happy with the way that you exercised that force. So again, even a statement like that seems fine. It seems fine to say something like, I was in fear for my life. Even that can and will be used against you in many scenarios.
Yeah, now that's your theory, right? You mentioned earlier about these crime prevention statutes. Maybe that would have been a better theory in the case. Maybe we would have said, hey, there's a statute out there that this person, our client, was acting under that didn't have to be in fear for his life, but, was attempting to prevent the imminent commission of this particular crime. But if you make that statement, that is now your legal theory. What if we also wanted to say, the person fired to protect a third party, was protecting another person because maybe the imminent threat was maybe better presented to that other person. But when you open your big mouth and said, the terrible general advice from other lawyers that don't do these kinds of cases exclusively, just always say you were in fear for your life, that we're now stuck with that. You can't get on the stand at your trial and say, well, I really fired because I was afraid that the bad guy was going to shoot or kill this other third party. Prosecutor's going to have a field day with that. Oh, really? Isn't that... That's not what you told the officer at the scene. At the scene, here's what you said, quote, put it right up on the big screen. I was in fear for my life. And the same with the crime prevention statute. So why? Look, your job is to make our job easy, not hard. You make our job harder when you throw the legal theory right out there at the beginning. We can always put you were in fear for your life later. That people know that's going to be the big justification. You could say it for the first time ever on the stand at trial, if you like. And maybe we want to put a different theory out there, and we want the prosecutor to learn about it for the first time on the stand at trial when the defendant's on the stand. So why broadcast what your theory is right there at the beginning? And I think it's because people are worried, the police officer's going to arrest me and take me to the station. Look, that's the small problem. Getting arrested getting charged is the big problem. Don't make it easy for them to charge you or harder for us to defend you if you get charged. If you're going to get arrested, the cop might say, look, you don't give me a statement, I'm going to arrest you. Okay, do the arresting. If you're not willing to be arrested, you shouldn't have pulled out that firearm in the first place. The situation wasn't serious enough.
So to summarize, don't limit your legal theories and just shut up. However, there are some times where silence can be used against you. And I want to remind people of the situation. Let's say there was a self-defense situation and officers respond and you're not being arrested yet. No one's read you your Miranda rights and they're starting to ask you questions and you remain silent. That is a situation where officers and later prosecutors can potentially argue that that silence shows a consciousness of guilt. In that situation, if you are deciding not to answer questions, which is what we would encourage you to do, that is a time where you want to assert your right to an attorney and your right against self-incrimination and inform the officer that you will not be answering questions and that you would like an attorney.
Yeah, there's a case out of Texas that the U.S. Supreme Court passed on. But, in that case, it was pre-arrest, pre-Miranda. And strangely enough, the defendant or the suspect at that point had already started answering questions, right? So the argument is, well, now he's answering questions. We get to the question about, those shotgun shells going to match your firearm? And then it was all of a sudden, I'm going to remain silent. And the prosecutor wanted to use that as consciousness of guilt. So, look, generally speaking, just simply remaining silent and saying nothing is going to be in your interest. Even better to just say, I want my attorney present. Remember, that never comes into a trial. I think some people don't understand the rules of the game. The prosecutor doesn't get to put the cop on the stand and say, Mr. Friendly Officer, did you ask him if he had anything to say? Yes, I did. And what did he say? He said, I wanted my lawyer present before I make any statement. Like, that's a mistrial. That isn't, at least an argument for a mistrial. That isn't permitted in court. They don't get to comment on the fact that you invoked your right to remain silent. I think a lot of people don't know that rule. So don't worry about that being used against you. It's not a reason that goes to the probable cause analysis for the arrest. It's not a reason that goes to the probable cause analysis for charges. It's a right that you have under the Constitution to remain silent, to say you want a lawyer. It's not used against you. Really, early and often, I want my lawyer present. I'm not making any statements. That's perfectly fine. Like I said, be firm about it.
That's right. So, by and large, in most situations, your silence cannot be used against you. But if you're in that pre Miranda, pre arrest situation, you don't get to pick and choose which questions you get to answer. Just assert that right. Say, I'm not going to incriminate myself. Well, don't say that, but say, I want my attorney. Um, the next thing I wanted to talk about a little bit more was that don't get shot element. Put yourself in the mindset of a police officer responding to the scene. Again, they don't know what they're responding to. So if they see you with a firearm, they're not going to know if you're the aggressor or if you're the person defending yourself. They don't know if you're someone that loves cops or is nervous about getting arrested by a cop potentially. So if they see you holding a firearm, they are going to protect themselves.
Yeah, and let's be real here. I mean, I've dealt with a lot of police officers over 3 decades doing this. I think it's fair to say their attitude is, you know what, I'm going home. I'm going home to my wife. I'm going home to my kids. And the job doesn't require them to take a bullet. And so they're going to be very, very cautious. Strangely enough, you might keep this in mind that really the most dangerous thing for a police officer is going to be a traffic stop, right? When they pull people over, they don't know what they're facing. I know we're not talking traffic stops, but if you get pulled over, absolutely do everything possible to not appear as a threat, right? Keep the hands on the wheel, that's a bad time to be looking for your firearm. You might be thinking, well, I'll tell the officer I got a firearm or I'll get it to hand it to him or something like that. Bad idea. Keep it where it is. And again, if different states have different rules here, but if the officer's not asking about a firearm, again, keep your mouth shut. Don't crack that can of worms. The last thing you want to do is appear to be any kind of a threat. I don't care if you love cops or hate cops. At least pretend that you love cops during any interaction with, I would say, any involuntary interaction with a police officer. That's any time the blue lights come on or the officer says, hey, hold on, I want to ask you some questions. Don't appear to be a threat at that point. Their attitude is they're going to go home.
And we recognize that these situations are all different. They're all flexible. There may be some situations where it's dangerous to put down your firearm right away after calling 911. Maybe the threat is still active and you need to keep your firearm close. Maybe there's times where you're very confident the threat is neutralized and you have time to go safely put away your firearm in a safe. But there may be times you have to set it on a table, or maybe there's times where you just take the mag out. So there are different responses in different situations in order to keep yourself safe. But remember, safety is a priority in these situations for yourself. So remember, don't get shot in these situations. Be mindful of what an officer is going to see when they respond to the scene.
Yeah, and again, another huge advantage for AOR clients, call us. We deal with these situations all the time. We like the challenge of what are the facts, right? And, usually the first thing we're going to say is, are you somewhere we can have a private conversation, right? If no, then people are listening. It's not, they can report anything they've heard. So we want a private conversation, but we're going to ask you what happened, what's the situation, and we're going to sort of triage that, right? Are the cops coming? Is the firearm in your hand? Okay, first chore here is make sure client doesn't get shot by police. Get that safe. We may even want to call 911 and talk to them and give them some information. We can do that as well. So call us, use us. Every situation really is unique. Don't do this by yourself. That's why you signed up in AUR. You got a whole team of criminal defense lawyers who do nothing but self-defense cases. We handle these kinds of things. Call us. Take advantage of that. We want to keep you not just safe, but away from being charged. Okay, look, sometimes you get charged. If you do get charged, we're happy to do the case for you. But it's really better for you to not be charged. Like, we love trying cases at our firm. We have trial attorneys, but we're not confused about the fact that the best thing for the client is to avoid charges in the first place.
The last mistake I wanted to discuss today, Mark, is whether or not you should leave the scene after a self-defense incident. And this is another situation where I would say it depends. There might be a situation where you're facing a serious threat and the threat is still active, and your best course of action is to retreat and leave the scene in order to get to safety. However, there are some times where your decision to leave the scene could be used against you by a prosecutor.
Yeah, it's a really good point, right? We had the case in New York. People can check out. We got a testimonial on that one where our client did leave the scene, and it was the right thing to do because the scene was unsafe at the time. It was literally a mob chasing him, and so he had to leave the scene. And we made decisions later on, and he turned himself in. Right, that was the one. His car was at the scene. He certainly would have been identified. We might not always make that decision, but if you leave the scene and the prosecutor figures out who you are, you know they're going to make the argument. The reason you left the scene is because you were conscious of the fact that you were guilty. You just committed a crime. That's why you were fleeing the scene. So, look, if it's an emergency, like the case in New York, you don't have time to call us. Although we have had AOR clients calling us as they were running away from the scene. Andy took one not too long ago. A client was literally, had people chasing him and got on the phone, was talking to Andy as the thing was happening. So that could happen too. But call us, let us make the decision, because if we can argue that, no, he didn't leave the scene because he was aware of the fact that he was guilty, left the scene because it was unsafe for him to stay at the scene, that's fine too. But if the scene is secure and you know the police are coming and there's no reason you can't stay and you get in your car and you drive away, that's almost a guarantee they're going to get what's called a consciousness of guilt instruction, which is essentially going to tell the jury, if you find that the defendant left the scene, then you can consider that might be consciousness or awareness of the fact that they were guilty of the crime. You can roll that into your determination of whether the state has proven that case beyond a reasonable doubt. I really don't want that jury instruction in a case where especially a close call case where it's going to be hinging. Think about this, right? You're in a situation where jury's going to come back guilty or not guilty. If they come back guilty, you're going to spend many years in prison. If they come back not guilty, you're going to walk out of that courtroom and we're probably going to have a nice dinner somewhere. We want every possible advantage that we can get in the case. And so this is, again, why I keep coming back to the thing that you call us. Let's make the decision together. We're on your side. You're paying us for legal counsel. Call us. Take advantage of the strike force. You're going to get a whole team of lawyers. Even though there'll be a lawyer on call, you'll be talking on the phone. Every lawyer at the firm is checked into the strike force. We all monitor what's going on. And so if there are going to be hard decisions, we're going to huddle up and make that decision together as a team. So you're going to really get, this is why AOR is such a unique service. You're really going to get not just a lawyer, but a lawyer who does exclusively self-defense and the entire team of lawyers on the case, all working together to try to get you the best legal representation. That's why nobody can touch us in this industry. It's just the truth.
That's right. So I always say there's two pieces of legal advice that apply to almost all self-defense situations, that being just shut up and don't get shot. But I think I'll add, as a third, just call AOR as well after the fact. And so I lied. That wasn't the last mistake. I'll say as a bonus mistake people make is not hiring an experienced criminal defense attorney that has specialized in self-defense in some way. So like you said, all the attorneys at Attorneys for Freedom are exclusively committed to self-defense cases. This is what we do. My practice is limited to self-defense. And we see many people hire attorneys maybe that just dabble in self-defense, or maybe they even just dabble in criminal law to begin with. Maybe you hire your friend that does contracts or family law, and maybe they'll give you a good deal, but a good deal on the price may end up with a bad deal in the courtroom. So you need to watch out for that. Be sure when you are in these kind of situations that you consider hiring an experienced criminal defense attorney.
Yeah, we haven't had AOR for 30 plus years, and I've been practicing. We've had the firm this whole time, and seeing people struggle, right? Imagine the person who hasn't really planned for this in advance, and they get into some kind of a discharge of a firearm. Usually they get arrested, they get taken to the jail. Now you're left with the girlfriend, the wife, who's scrambling around, trying to find a good lawyer. They can't get people on the phone. They have no idea who's good, who's not good. They just want somebody to show up in court and try to help their husband or spouse. Like, it's a terrible time to be trying to, sort through the internet searches and figure out who's a good lawyer. You have no idea. People put up a good website. They might have one website for their criminal defense side and the other for all the family law, divorce stuff they do. You don't know how many cases they've had or what their experience is or how committed they are to these kinds of cases. It's really the kind of thing that you should do in advance. I mean, if you're going to carry a firearm, there are some things you should be thinking about, like, am I proficient with the firearm? You got to go to the range. You got to make sure that you're a good shot, right? I mean, at the end of the day, that's how we see gun control, making sure that if you're going to put a round down range, you are going to hit what you are aiming at. That's something you got to commit to if you're going to carry a firearm. Another thing is legal knowledge. You got to have, look, you are presumed to know the law. You're not going to be able to come to court and say, I thought I could do this, but I'm not a lawyer. I don't know what I could do. Nobody's going to have any sympathy for that position. If you're going to carry a firearm, you are required to comply with the law, whether you know what it is or not. We've all heard ignorance of the law is no excuse. And the third thing, I might need a lawyer. If I discharge a firearm or I pull it, I'm probably going to need a lawyer. This is the kind of thing that AOR is for. That's why we want competent, responsible firearms owners who want training, who want these kinds of events so they can listen to two lawyers who don't do anything besides self-defense, yak about different scenarios. They get the series that Andy and I are going to do, and we're coming up with the hardest hypothetical questions to really kind of sort of split most rooms on, is this a good shoot, is it a bad shoot? We're playing around with these facts just like a law professor would do in law school. Why? Because we want our clients to understand the law, what they can do and what they can't do. Our goal really is to keep people safe and free, but you can't always, you don't get to choose when a self-defense situation arises. And if you do make a mistake, at least with us, you don't have a criminal acts exclusion. If you blew it, we still got your back. And I think that's one of the reasons why people really like AOR. They're dealing with a law firm of lawyers that love to do self-defense cases, and we're not going to kick them to the curb just because they blew it. If they did it, if they in good faith tried to act in self-defense and they blew it, look, we may give you advice that you may need to take a plea. This might not be one you want to take to trial because you blew it, but we're not going to leave you hanging. And if you still decide you want to go to trial, fine. We're going to fight our hardest for you at trial. We're playing. We want to win. Can't guarantee you a win, but we can damn sure guarantee you we're going to put on the best criminal defense we're able to put on for you, including experts, investigators. Like, we want to win, so we're going to do everything we can to protect our clients.
That's right. And I think we want to go to one last question. So the Joseph Santos asked, for purposes of raising self-defense, how does a defendant safely argue that he or she has been threatened previously by the other person and reasonably believed a current threat is real?
Yeah, that's tough. I mean, if you're arguing you've been previously threatened, like, what do you mean by previous? You mean like someone's been making threats over the last several weeks or months or years? Like, that's not going to get it for self-defense. I mean, the law is going to say you got to charge into court and get an order of protection, injunction against harassment, a restraining order, depending, these are called different things in different states. But if you're not dealing with an imminent threat, we kind of end where we started, right? If you're not dealing with a right now threat, regardless if somebody's been making threats in the past or was never making threats in the past, if somebody is making a threat right now that is imminent, you can act. The mere fact that they made threats in the past is only going to get you so far. If there's no threat going on right now, it's not a self-defense matter. That's how I see the question. I don't know what they meant by previously. If it was, they made 3 threats in a row, and now all of a sudden, I'm going to punch in the face, I'm going to punch in the face, now here I come with my fist like this. Okay, that's good. That's going to be relevant. But if you've had problems with your neighbor over the past several months, and I'm going to punch you in the face, and then you see the neighbor one day and you go up to him and punch him in the face because he's been threatening to punch you in the face over the last several months, you're the one who's going to get charged. That's just how it works.
Exactly. So I think that wraps up all of our questions today. But if you think of any questions later on, do not hesitate to reach out to us. We are very easy to reach. Our contact information is on our websites. So if you want to learn a little bit more about Attorneys on Retainer, check us out at attorneysonretainer.us. Attorneys on Retainer is a self-defense protection program. There's just a few criteria for coverage. So if you are a member of Attorneys on Retainer and a self-defense incident arises after you are a member, you are charged with a crime, or you reasonably expect to be charged with a crime, and your defense to that crime is self-defense or defense of others, you will be covered. We also have some other great benefits that you can read about on our website. We also have recently added red flag law coverage, so again, check us out at attorneysonretainer.us. If you want to learn a little bit more about our law firm, Attorneys for Freedom, check us out at attorneysforfreedom.com. Get to know the whole team. You can see our contact information there. And I mean it. If you have a question, feel free to email me. I'm a legal nerd, so I love answering these kind of questions. So do not hesitate to reach out. And you're watching us on YouTube, so you might as well go ahead, like, comment, share, and subscribe. Thank you again, everyone, for tuning in to the Attorneys on Retainer live stream. And be sure to avoid some of the mistakes we went over today. This is Rachel and Mark signing out. Peace.
Peace.